offers. So I'm going to talk about the listing agent duties with multiple offers. And I'm just going to remind you of Idaho license law. Of course, all of our presentation comes from this right here. You're all familiar with the license law book. That's the Real Estate Commission's job, is to protect the public in their real estate transactions through implementing license law and having licensees adhere to those rules. So when it comes to multiple offers, which many parts of the state are receiving multiple offers, it's a seller's market, as you know, really out of balance in some areas, favoring the seller. And so multiple offers are getting quite common. So I'm going to talk about the listing agent duties. You do have to present all offers to the seller. Every written offer signed by a seller is considered a bona fide offer in all respects and must be presented to the seller. There is no circumstance where the listing agent gets to filter which offers get to the seller and which don't. Even if the property is pending escrow and maybe there's some backup offers that have been accepted, you still have to show the seller all offers up until the time of closing, and then your seller doesn't own it anymore, and then the obligation ends. The Real Estate Commission has historically received frequent complaints from buyer's agents alleging that the listing agent stated flatly that they would not present this offer to the seller for one reason or another. The listing agent may never take that tact, even if the seller says, listen, I'm done seeing, we have a good offer, we have a backup, I just don't really want to see any more offers, don't send me any more. Your only response is, I understand that, I empathize with that, but the rule for me is I have to send them to you. If you don't want to look at them, if you don't want to open it, if you don't want to respond to them, that is your prerogative, but I do have to send them to you. Treat all parties honestly and professionally in a multiple offer situation. If there's 5 offers, 1 buyer is going to get it, and 4 are going to be disappointed to learn that they did not get it. Let's not give them additional complaints that they were treated wrong by a real estate agent. Everybody's treated honestly, ethically, and professionally. There's a lot of mechanisms to do that. But let's treat everybody honestly and fairly, and not give them a complaint that their offer was not treated properly. Now, the Real Estate Commission gets increasing complaints from buyers that, in fact, Director Bird was just telling me that the other day that a complaint came in from a buyer saying, I know my offer was the best offer. I don't know why the seller would take a different offer than my offer. I know my offer was the best offer. So the director explained to that person that the seller may choose whichever offer they want based on whatever criterion they want. And you all know this. Sales price is only one component of an offer. There's other components of an offer that would compel a seller to choose that offer over another, and that is the seller's prerogative. Let's talk about expiration date and time. So this is another issue that the compliance staff gets calls from buyers and buyers agents all the time that the seller wouldn't respond to the buyer's offer by the expiration time and date. They continue to complain that not only did they ignore our expiration date and time, they're continuing to hold open houses. They're continuing to collect other offers. Those are all permissible activities. And even though that is frustrating to the buyers and their agents that have submitted an offer, the seller may indeed shop those offers, continue to collect additional offers, hold open houses, continue marketing the property for sale, and ignore the deadline. So I think we're going to talk about how to help the buyers through that frustrating circumstance if it happens. But you need to remember to always promote the best interests of your seller client when you do have a seller. Advising the seller to sit and wait to collect additional offers for the sole purpose of trying to get an offer yourself so you can double end it and encourage the seller to take that one, I don't consider that as promoting the seller's best interest necessarily. I think that's promoting your own self-interest. If there's a good offer on the table that the seller would like to take, advise the seller to take that particular offer and don't use time to try to get one for yourself. So that's a little bit of a discussion on the listing side. I'm going to hand the baton over to Director Bird to talk about buyer's agent's duties and multiple offers.
Thanks, Mike. I see that there was a question in the chat box that I'm going to have you answer first. And
yes,
Jim,
thank you, Director.
Jim asked, why not require all offers be initialed or signed and dated by a seller? That way, there is never going to be any doubt the seller actually saw the offer. And I believe you have the historical take on this.
I've been in the business long enough to remember that that was the requirement when I first got into the business. And I know there's a lot of people on this call who have been in the business long enough to remember that there was a license law requirement that the seller initial that they'd received the offer. And for whatever reason, no one ever did it. There was virtually zero compliance. So the legislature took it out. So I don't think, I don't know if there's an appetite to try to get that requirement back in. We used to have the requirement. It was uniformly ignored. And so that's why it was removed. So I understand that that sounds like a good idea. And if everybody would do it, that would be wonderful. But I don't know if it happened. And that's
Thanks,
all I got
Mike.
to say. Okay.
Yeah, and I think, you know, if you do that as an agent, then good for you. That could create some trust with your clients. So that is a personal decision. It's not in license law, and like Mike said it used to be, but it was taken out well before my time. Not that you've been in it way longer than me, Mike, but you have. So. So on the buyer side, we're going to talk about that just for a minute. The most important thing is you all know what the market conditions are, and it is creating frustrated buyers. And I'm sure you hear from those frustrated buyers much more than I hear from them, but I actually hear from them too. So we ask you as your buyer's agent duties to write the offer correctly and make sure you have all of the terms and conditions correct in your offer. So one of the problems that we're starting to see based on this frenzied market is that when buyers have started losing out or not getting their offers accepted, sometimes they get so frustrated that they want to make multiple offers on making simultaneous offers on multiple properties. So their strategy, I guess, is I will make offers on 5 properties, hoping to get chosen and get under contract with one of those properties. Now, most of the time, they do not intend to close on all of the properties that they're making offers on. Quite honestly, we're hearing that they're making offers on multiple properties with the hope that they fall under contract with one. And if potentially they are in contract on multiple, then they'll just cancel the rest under an inspection clause. We actually have a problem with that. We feel like canceling contracts for this reason could be harming the sellers, and we actually could consider it an adverse material fact. So if your buyers are making multiple offers, the adverse material fact, so Mike has up there, the adverse material fact is a fact which establishes a reasonable belief that a party to the transaction is not able or does not intend to complete the party's obligations under the real estate contract. And we feel like this could fall under that. So what do you do? Well, we would tell you that you should inform all parties that this is what's going on, that your person has made multiple offers and they may not be, or they probably are not going to be closing on all of those, completing those offers. So communicate with everyone involved in writing would be best. But what can you do to help your buyers? So, you know, mostly just communicate with them, inform the buyers of the seller's options. And Mike kind of already went through these. He talked about sellers can choose any offer they want. Well, most sellers or a lot of buyers don't understand that. And so I am getting those phone calls. I know mine was the highest. And I have to explain to them the seller can choose any offer that they want. The seller may be looking at a cash offer over an offer that has to be financed, or the closing date might be more attractive to them that you offer. So communicate with your buyers, let them know what happens in this market. Don't let them be surprised when their offers are not being accepted. I think a lot of times communication can go a long ways. And about that, so a lot of you were probably in the commission meeting when we were up in Coeur d'Alene, or there were a lot of people on virtually as well. And we asked, what do you want to hear in next year's core? And we have continuously gotten etiquette, how to be ethical as an agent, how to have good etiquette with each other. People are being rude. Well, it's hard for us to teach that, but keep that in mind. So communication would go a long ways towards us not getting those phone calls or those complaints that say this agent is not doing it right, just because their etiquette may not be what everyone would like it to be. Do you have anything else on that, Mike?
Yeah, Scott Latham asks a good question in the chat. He said, what's the commission's stance on the on offer deadlines? Quote, seller to review offers on Tuesday at 5 p.m. and reserves the right to accept an offer prior to that. The commission's stance is that is a permissible statement or declaration, assuming that the seller has instructed the listing agent to do that, or they've discussed it. The commission is not, doesn't have any, that is not a license law violation. That's just simply another tactic that listing agents use in a market like this. So that's the commission's stance on that, Scott. Good question. The next topic that we were going to talk about is offer expiration date and time. And I mentioned this, so I'll go through this real quickly. Again, most offers, especially if you use the Realtor form set, we have a place in there that you fill in when the offer expires. That expiration date and time simply means that the offer ceases to be binding on the buyer at that time. The seller is not required to respond by that time. And that is a question that I mentioned just a few moments ago that the commission's getting a lot. Frustrated buyers and their agents complaining that the seller didn't respond to our deadline. Seller doesn't have to. If the seller accepts the buyer's offer after the expiration date, we don't have a deal yet. The buyer has to countersign or acknowledge that late acceptance before you're under contract and can proceed forward. You all know this. So I think the takeaway for us that you probably knew everything that I just said already is inform the buyers what that means, so that they're not under the impression that the seller has to respond by that deadline. I think that's your best step. All right. I don't know if there's any questions on that. That one's pretty straightforward. Let's go to the next topic, number 3. I'm going to hand this off to the director to talk about electronic forgery.
Thanks, Mike. So I know that we would like you to put the best interest of your clients first. But we don't want you to get in trouble trying to do that. And one of the things that we're seeing with these quick deadlines and quick turnarounds, we have started to see some assistance by electronic signatures that the agents are logging in and signing electronically for their clients. And this is the same as a forgery. We consider it a forgery. We've had a few cases recently that we have pursued based on this. And what we are seeing is that the agents are just going in, changing the email so they get the ability to sign. And most of the time, what we're hearing back from the people that we're talking to in investigations is a deadline was imminent. My client was not available. They told me that I could sign it, and that's not good enough. It's still a forgery. So unless you have a power of attorney, don't do that. I'm sure you all know that, but the electronic signatures is the same as you actually signing your name on the document. So again, verbal, text, or email instructions are not sufficient. You must have power of attorney if you're going to sign for your clients. So we unfortunately have had a couple of cases of this in the last year, and you know, it may seem that you are assisting your client, but let's not get you in trouble by assisting. Anything on that, Mike?
Well, yeah, I just wanted to underscore that I think everybody on the call would bristle at the notion of taking a contract in person and taking a pen and signing somebody's name. We all know instinctively that's wrong. It somehow feels justified or not as wrong to do it electronically, but it is still forgery. All right. That's all I wanted to add. Okay. Several have asked if they can get a copy of this PowerPoint presentation. I will be happy to send a copy to the Idaho Realtors at the end of the meeting, and they can disseminate it to anybody that wishes to have it. Maybe you can have an office meeting and use it. You're more than welcome to do that. So here's the last topic. I got a call yesterday from a person in Valley County who wanted to get her real estate license. And I told her the procedure to get a license. And then she said towards the end of the call, well, there's one more thing I want to chat about. I had a felony conviction in my background, and will that prevent me from getting a license? And I told her not necessarily. It adds an additional step that the real estate commissioners have to approve somebody after determining they're suitable for a license. But I did ask her when any court-ordered supervision like parole or probation ended. And she said, well, I'm currently on probation, but it's just about ready to end. And I said, unfortunately, I have some bad news for you. License law will not allow the commission to accept an application for licensure unless 5 years have passed since the last day they had any court-ordered supervision. So unfortunately, she was stuck for several years before she could even go through the process. And then she said, well, the broker I wanted to work for said that I can become a referral agent.
What?
I mentioned this to Director Bird, and she said, Mike, we get calls at the commission regularly about what is a referral agent and how does it work? I don't have to be licensed, right? So let's go over the rules for a referral agent. First off, it is a licensed real estate agent. You have to have a real estate license to be a referral only agent. You have to be on active status with the broker. Thereby, you have to have errors and omissions, and you have to do your CE just like everybody else. A referral only agent is merely a label for a licensed agent that is not a realtor member or an MLS member. So they're able to save those fees. So it's really referral only agent is a term that was invented by the Realtor Association, as far as I know, to allow. So for instance, the rule is that I'm a realtor member, and every designated broker on this call is also a realtor member. And the rule is if anybody licensed under my company or your company, they have to be a realtor as well. Our licensees may elect to not be a realtor. Everybody's in. Well, the rule, I have a second company, and it's called the referral only company. just by me, it's called a referral only company. So I have 5 agents in this referral only company. They're actively licensed with the Real Estate Commission. And the rule is because I'm a realtor, it's a different company. They don't have to be members of the Realtors or the MLS, and they may simply make referrals and be paid on the referrals, because to be paid on a referral, you have to be active when you made the referral. So that's the referral only agent status. There seems to be a little confusion about who can be paid on referrals. Remember, you have to be actively licensed with a broker to be to send a referral that you will be paid on later. I don't know if there's any questions on that.
Mr. Chairman, there is one. Mark Linscott asks clarification, specifically referral to an attorney who is not a licensed agent or broker. Is it permissible?
I'm going to hand this one off to the director.
Thank you, Mr. Chair. I'm not sure how to answer that. So.
Mike Johnston, what do you think? I don't think that just because they're an attorney, they're able to receive a referral fee. They're not licensed. I don't think there's a carve out in license law that allows a broker to pay an unlicensed, unreal estate licensed attorney a fee. Is there? Mike, do you know of one?
I'm not
This
sure
is
Mike
John
is paying
Adamson.
attention.
I've always been told that attorneys can practice real estate without a license. And if they can do that, I think they would probably be entitled to receive a referral fee.
There is an exemption to licensure that allows a licensed attorney to write contracts in behalf of their clients, real estate contracts. There is an exemption for the practice, real estate practice. I don't know if that would necessarily extend to this particular topic. Director, maybe we should roll this around a little bit and perhaps talk to your compliance department and see what they say, and we can get back with the realtors, and maybe David Hensley, maybe we could get the answer back to you, and then you could disseminate it to your members. Would that be okay?
Mr. Chairman, that'd be great. And as a licensed attorney in the state of Idaho, I'm happy to provide you with any sort of insight you need on that question.
Okay. Yeah. Let's get that hammered out. I don't want to, since I'm not entirely sure, nor is the director, maybe we just not out of venture an answer quite yet. So how about we get back to you on that one, Mark? Any other questions?
Mr. Chairman, Director, we did get a question about love letters, whether or not they should be presented to the clients, and if so, is there a timing function associated with that? That came from Tina Turner.
Jason Risch has given some really good direction on love letters, as has the National Association of Realtors. So those are 2 other good resources. The real estatement comes out any day now. The little every 6-month magazine that the commission sends out. And I wrote an article to discuss 3 topics, and the 3rd one was love letters. So that will be coming out. But just to give a little synopsis of it, really the love letter, there's 2 things to look at. As a buyer's agent, it is recommended that you not assist the buyer in writing their love letter, and that you not even read the love letter, that you simply stick it in an envelope and supply it to the listing agent. I'm going to back up a quarter step and say everybody's concerned with love letters is federal fair housing violations. That's the concern. There are a couple of federal lawsuits worming their way through the courts in the country, not in Idaho, where buyers submitted a love letter And whether the language of the love letter or the photo of the family indicated they were a member of a protected class, their offer was not chosen, and they now claim that the sellers discriminated against them. So the issue of love letters really strikes at potential federal fair housing issues. That's the whole issue with it. So it's recommended real estate agents not help the buyer write the love letter and not read it. As far as a listing agent is concerned, it's recommended that you discuss with your seller client the issue of potential love letters, and that a buyer may submit a letter with their offer. And if they do, ask the seller if they want to see them or not. It is permissible for a seller to say, I don't want to see any love letters, and then the listing agent does not have to present the love letter to the seller. Really, the seller kind of drives this particular love letter issue. A seller should be encouraged always to select the offer that they want to take based on the criteria in the offer, and not because of any other factors, whether or not the buyer is a member of a protected class. So I don't know, Tina, if that got you the answer that you were looking for. Here's another issue, and this has come up in class and at my real estate school. The buyers are stalking the sellers on social media to learn something about them, so that they can write a love letter that plays to that particular thing that the seller will acknowledge or appreciate. And the buyers are actually lying, for lack of a better word. They are writing a false love letter. They're lying in their love letter to get the seller's attention. And I couldn't believe that somebody said that in class, that was happening. And another student in class wrote a letter and said, I did that. Before I was licensed, I wrote a letter to the seller, and what I put in there was not the truth, but I wanted to get the property, and it worked. So that's another weird issue about the love letters. You're not entirely sure that they're going to be accurate. But Tina, did that help you on love letters?
Yes, it did. Thanks.
Sure. Any other questions? I'm looking down the questions here. I had a buyer write an offer. Mike Mountain asked this. I had a buyer write an offer on my listing and made a love letter and exhibit. At that point, I was compelled to present it, which is true. I've heard of that. If they make it an attachment to the contract, then you are required then to present it, which I've heard that's happening as well. Any other questions? Okay.
I saw that Krista asked a question about the real estate being on our website, and thank you for the reminder. I believe we can get that on the website today, but you all should be getting your real estate statements in the mail this week. They were at AutoSort early in the week, so they should be in the mail. A lot of the topics that we've been talking about are forefront in our mind. Mike and I both wrote articles in the real estate statement that are that we addressed today too. So thanks, Krista. It will be up soon.
So Cindy, President Cindy, if we'll stand for any additional questions on any other topics, should your members wish to talk about them.
Okay. If anybody has any questions, if you could please put it into the chat at this point, or if you'd rather, you could raise your hand and hopefully we can see that as well and call on you. I know that we did have some questions on forms come up last year. The forms committee traditionally meets in person, and it's a 2-day meeting. And obviously because of COVID, it had to be postponed last year. We're working on hopefully being able to catch up on that and work on virtual meetings this year, because it does look like it's probably going to be summer before we're able to meet or late spring before we're able to get that together. So I know some folks had asked about that and about when the forms updates were going to be coming out. I believe we do have a question from Jim Paulson. And
Hi, Jim. I keep seeing emails from companies as advertising companies that sell individuals leads and they are not licensed. How do we shut them down? I have a comment on that, but I'd first like to turn that over to Director Byrd if she'd like to address that first.
Go ahead, Commissioner Gamblin.
So I had a discussion with Craig Boyack a couple years ago about this on this very topic, because there are companies that mine for leads and then they sell them back to us. And if they do not have a active real estate license in Idaho, that is a prohibition. But Craig said we just need to be selective about who we go after. And it's like whack-a-mole. If we go after one and we are able to knock it down, then another one pops up the next day, or they may reinvent themselves under another business name the next day. Is that I just think that's just a part of the business and our technology and the way it's going to happen. And we have a lot of other license law violations that are prioritized over that activity. And we just simply don't have the manpower to go over everything. Plus, he said, you know, we're not going to take on Trulia and Zillow and even Realtor.com for doing that type of activity and checking whether they have a license or not. So I know that's not the answer that you want to hear, Jim, but I think that's just a reality of our world, and the commission doesn't have the resources to continually knock them all down.
Well, for what it's worth, Mike, my recommendation on that would be if we can quantify that a company is in fact doing that, I would suggest that the commission just send them a cease and desist order or ask for proof that they're licensed.
That's a good suggestion. So I will forward that on to or MiChell can forward that on to the compliance department for their thoughts on that. So.
thank you, Mike.
That.
David, did you have a question as well?
Well, Mr. Chairman, Director, in the few moments we have left, is there anything on the legislative front for IREC that you want to make our members aware of, or anything we need to know from your perspective that may occur during the legislative session?
Well, I guess I will take that one since I'm spending my time there this week. So as the commission, we only have one piece of legislation that we're running this year, and it is just a cleanup bill. Last year we took the requirement for brokerages to have agency office policies on agency. We removed that requirement, and so we had one piece in our Idaho code that referred to it, and we are removing that. We're also changing the definition of business opportunity. It is a cleanup item as well. So our legislation this year is not super exciting, and we don't think that it will be a problem. It's just simply cleanup. As you know, we have been put into an umbrella agency. Last year, the governor signed an executive order that placed real estate into the Division of Occupational and Professional Licenses. And we are working on some legislation just kind of to work on the structure of what the Division of Occupational and Professional Licenses looks like. Now, as far as the agents go, you guys should not see a change based on those parts of our legislation. The only thing that will be different, that you should notice that's different under our reorganization, is we will be moving. So our office is no longer on, or will not be on, Loggers Creek in Boise any longer. In about 6 to 9 months, we're going to move out to Shindon. And for those of you that are local, we're going to be at the old Hewlett-Packard campus. So when you come to find us, we'll be in a different location. I want to thanks for bringing that up, because I want to throw out one thing. We had talked about in previous meetings that we were working on team legislation. And we actually have a draft. We talked about it at our meeting in Coeur d'Alene extensively. We got feedback, and your CEO and Max Pond and I have had a more current discussion, and we are going to work together this year on that team legislation. We did not move it forward to the legislature this year. And so we are going to work with the industry and with the association this year to hopefully put forward a piece of legislation that for next year's session. And CEO David, maybe you can address that a little more.
Well, thank you, Director. And I want to thank the Commission for their willingness to work on the issue with Idaho Realtors. I think collectively we saw that this is a huge issue with tremendous impacts across the industry. And what we wanted to do was take draft legislation and language to our brokers through our broker summits over the course of this year, and use those as forums and outreach to not only our brokers, but our members to get feedback on the legislation. The last thing we want to do is try to create law in a vacuum. I think we all felt it would be best to have as much input as possible from our members on this legislation. And so we felt the broker summits would be a perfect opportunity to do that. And so over the course of this year, we're going to use those forums and other opportunities to gather information from our members so that hopefully during the following legislative session, the 2022 session, we have a bill that we can all stand behind and proudly support to address the issues that we identify collectively together. So I was thrilled to have your continued partnership on that issue. And I look forward to working with everyone as we gather information, identify the issues, and start to present language that can address that. So thank you for that. And we're excited to move forward in that regard. We did have one question quickly that I want to make sure we get to, and I'll throw this open for either Mr. Chairman or the Executive Director. Who is responsible to ensure the buyer deposits earnest money in an escrow or with an escrow? Either one of you care to touch on that?
Director Byrd, do you want to do that, or do you want me to make a comment as well?
Yeah, go ahead, Commissioner Gamblin.
So the question was, just to repeat it, who's responsible to ensure that the buyer's earnest money deposit gets to escrow? There's nothing in license law that addresses this specifically and directly. So I think the commission's position is the licensees, both of them, need to make sure. The listing agent would do well to follow up to ensure that the buyer's deposit made it into the proper depository. And the buyer's agent should help the buyer comply with their offer that they are going to make an earnest money deposit. So a buyer that doesn't follow up with the buyer's agent that doesn't follow up with their buyer to make sure that happens also, I think would be viewed dimly by the Real Estate Commission. So I'm going to say both those agents working that transactions kind of has a duty to make sure it gets done. And
thank you, Mr. Chair. We have held both sides responsible in certain situations that we've had.
That's what I thought. Yeah.
Okay, well, it looks like we're about to finish up. I'm not seeing any additional questions. So I'd like to be able to thank Mountain America Credit Union and Jared for sponsoring the webinar today. And I would like to thank Director Byrd and Commissioner Johnson and Commissioner Gamblin all for joining us. And as a final note, in case you were unaware, Commissioner Gamblin will be stepping down this year. So I am in hopes that he's going to enjoy his semi-retirement. We will miss you on the commission, but I'm sure we'll be seeing you. Thank you very, very much for all of your years of service, friendship, and partnership with Idaho Realtors. And as an aside, Mike, I hope we see you up in Sandpoint this summer. So
That's the
anyways,
goal. That's the
okay,
goal.
good. Thank you everyone for joining us. And we will have this posted on our website. So you'll be able to see this later if you wanted to replay it or if you wanted to let a friend know about some of the information. It was great information. Thank you all very, very much. Appreciate everything. Take care.
Thank you.